She got one. Catherine has
So
one.
we got one.
I wasn't
And
thinking about her.
his client, right? And for you.
You didn't get that on the record.
So everybody got one, right?
Everybody good?
Yeah, we can take one back.
All rise. Hear ye, hear ye, hear ye. This Honorable Division of Criminal Court 10. The 30th Judicial District of the State of Tennessee is now open for the transaction of business pursuant to adjournment. All persons having business with this court draw near, give attention, and ye shall be heard. The Honorable Judge Jennifer Johnson Mitchell presiding. You may be seated.
Good morning. Any business we need to take care of before we bring the jury in?
No, Your Honor.
Mr. Evans, you'll be up first.
Yes, Your Honor.
You can bring in the jury. Ladies and gentlemen, before the jury comes in, I will start to read this jury charge very soon. There will be no movement during the charge. The door will be locked. Nobody will enter and nobody will exit. It's going to take me about 15, 20 minutes to read this charge. So if you don't feel like you're going to be able to sit still during this time frame, please exit now. Thank you.
Jury time, enter into the courtroom, y'all.
Good morning.
Good morning.
I trust again that everybody has a good night. Mr. Evans, can you call your first witness?
Your Honor, the defense rests.
Ladies and gentlemen, you have heard the proof in this matter. What you have had in your seats, is a jury charge. This is my portion of this trial. It's the law. Now, the law states that I have to read it to you. Please don't think I am insulting your intelligence by reading to you. I know you can read for yourself, but the law states that I have to read it and you all have to hear it at the same time. Okay? That is your copy. Feel free to write on it. I have the official copy here that will go back with you to the jury room. You cannot write on this copy, but feel free to make any notes that you'd like to make, and any changes that I have to make that I see that need to be made will be made on the official copy. Okay. State of Tennessee versus Justin Johnson. Members of the jury, the evidence in this case has been completed, and it is now my duty to instruct you as to the law. After I instruct you as to the law, the state and the defense may present their closing arguments. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. Duties of the court and the jury. The law makes it the duty of the court to charge the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them in the trial and under the law given them by the court. Render their verdicts with absolute impartiality. No sympathy or prejudice by the jury. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdicts. You must render your verdicts with absolute fairness and impartiality as you think justice and truth dictate. The indictment in this case is the formal written accusation charging the defendant with the crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made, do I mean to indicate any opinion as to the facts or as to what your verdicts should be. Statements and arguments of counsel. Statements, arguments, and remarks of attorneys are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made by the attorneys in this trial at any time that you believe are not supported by the evidence, you should disregard them. Along these lines, the opening and closing arguments of the attorneys are likewise not evidence. You must base your decision in this case on the evidence that was actually presented in this court, not on the statements of attorneys. Furthermore, the questions the lawyers ask the witnesses are not evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is true. Jury, judges of facts and law. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of this court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experiences in life. Presumption of innocence. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Reasonable doubt. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element necessary to constitute the offense. Crimes charged and pleaded. The first count of the indictment charges the offense of conspiracy to commit first-degree murder. Embraced and included within the offense are the lesser included offenses: facilitation to wit, conspiracy to commit first-degree murder. The second count of the indictment charges the offense of first-degree murder. Embraced and included within the offense are the lesser included offenses of second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. The third count of the indictment charges the offense convicted felon in possession of a firearm. The court will now explain to you the law applicable to count 1 in this indictment. Conspiracy to commit first-degree murder. Any person who conspires to commit an offense is guilty of a crime. For you to find the defendant guilty of conspiracy to commit first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained, and that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder, and that each party acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder, and that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of this conspiracy. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that they be completed is abandoned by the person and by those with whom the person conspires. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation. If an individual abandons the agreement, the conspiracy is terminated as to that person only if and when the person advises those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of the conspiracy and of the person's participation therein. However, mere presence is not sufficient to support a conviction. Facilitation to wit, conspiracy to commit first-degree murder. Any person who commits the offense of facilitation to wit, conspiracy to commit first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of conspiracy to commit first-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the conspiracy, and that the defendant furnished such assistance knowingly. Conspiracy to commit first-degree murder has been defined on page 4. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances, or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable in count 2 in this indictment. First-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, Adolph Thornton Jr., and that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted knowingly. Knowingly means a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Facilitation to wit first-degree murder. Any person who commits the offense of facilitation to wit first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of first-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the first-degree murder, and that the defendant furnished such assistance knowingly. First-degree murder has been defined on page 8. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, second-degree murder. Any person who commits the offense of facilitation to wit, second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of second-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit from the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the second-degree murder, and that the defendant furnished such assistance knowingly. Second-degree murder has been defined on page 9. Knowingly means that the person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted intentionally or knowingly, and that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions which renders the mind incapable of cool reflection. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally or knowingly caused bodily injury to another, and that the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, voluntary manslaughter. Any person who commits the offense of facilitation to wit, voluntary manslaughter, is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of voluntary manslaughter, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the voluntary manslaughter, and that the defendant furnished each such assistance knowingly. Voluntary manslaughter has been defined on page 13. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any person who, facilitation to wit aggravated assault. Any person who commits the offense of facilitation to wit aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of aggravated assault, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the aggravated assault, and that the defendant furnished such assistance knowingly. Aggravated assault has been defined on page 14. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Simple assault. Any person who commits a simple assault upon another is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant caused bodily injury to another, and that the defendant acted either intentionally, knowingly, or recklessly. Facilitation to wit simple assault. Any person who commits the offense of facilitation to wit simple assault is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of simple assault, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the simple assault, and that the defendant furnished such assistance knowingly. Simple assault has been defined on page 18. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable to count 3 in this indictment. Convicted felon in possession of a firearm. Any person having been convicted of one of certain specific felonies who possesses a firearm is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant had been convicted of a specified felony, and that the defendant, after such felony conviction, possessed a firearm, and that the defendant acted either intentionally, knowingly, or recklessly. Firearm means any weapon that will or is designed to or may readily be converted to expel a projectile by the action of an explosive. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find from the proof that the defendant has been convicted of another crime or crimes than that for which he is presently on trial, you may not consider such evidence as proof of his disposition to commit the crime for which he is on trial. The defendant has pled not guilty to each and every offense charged and included in the indictment. Direct and circumstantial evidence. One type of evidence is called direct evidence and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. Accomplice. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. You should consider all the evidence presented in this case by the state and by the defendant and give it full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors: how the witness looked, acted, and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Whether the witness was in a position to know about the matter to which he or she testified? In other words, how well could the witness see or hear what he or she testified he or she saw or heard, whether the witness's statements were consistent and how believable the statements were, whether the witness had a motive to testify truthfully or to testify untruthfully, and any proof presented of the witness's reputation for telling the truth. All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Another factor for you to consider in evaluating a witness's testimony is whether the witness has made material statements at some point before he or she testified which are different from his or her testimony at trial. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of any prior different statement may be considered by you only for the purpose of determining if the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. Criminal responsibility for conduct of another. The defendant is criminally responsible as a party to the offense of first-degree murder if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or result of the offense, the defendant solicits, directs, aids, or attempt to aid another person to commit the offense. Intent means that the person acts intentionally with respect to the nature of the conduct or to the results of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. To find a defendant criminally responsible for the acts of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Absent material witness. When it is within the power of the state or the defendant to produce a witness who possesses peculiar knowledge concerning facts essential to that party's contention and who is available to one side at the exclusion of the other, and the party to whom the witness is available fails to call such witness, an inference arises that the testimony of such witness would have been unfavorable to the side that should have called or produced such witness. Whether there was such a witness and whether such an inference has arisen is for you to decide, and if so, you are to determine what weight it shall be given. This inference does not apply to the defendant because he has a lawful right not to testify, and his failure to testify cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Stipulations. A stipulation is an agreement between the parties. The parties have stipulated that certain matters of fact are true. They are bound by this agreement, and in your consideration of the evidence, you are to treat these facts as proved. The parties have entered into two stipulations. The parties have stipulated that Adolph Thornton Jr. was a living person who is now deceased, and an autopsy was performed to substantiate these facts. The parties have also stipulated to the fact that the defendant, Justin Johnson, is a convicted felon, previously convicted on May 2nd of 2017 in Division 8 of the Criminal Court of Shelby County. Flight. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community or leaving of the community or parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight. If flight is so proven, together with all the other evidence when you decide the guilt or innocence of a defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Multiple counts, finding of each required. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. Jury deliberation and unanimous verdict. The verdicts must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdicts must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Notes. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. Deliberation, order of consideration. In reaching your verdict, you should first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. That is the law, ladies and gentlemen. We will now proceed with closing arguments.
it's almost over, and I'm sure you all are happy. My name is Iris Williams. I'm one of the prosecutors on this case. And earlier this week, you heard opening statements. You heard opening statements from prosecution and from the defense attorney. And you were told all the things that you could expect this week. And one of those important things that you could expect was that it is not 1981 anymore, and that things have changed. But what does that mean? It means that it's hard to keep a secret. It's hard to hide who you're talking to. It's harder to hide your actions. And it's even harder to hide who you know. But ladies and gentlemen, despite all of those things that have changed, one thing has not changed, and that is the state's burden. The state's burden of proof is beyond a reasonable doubt. So what does that mean? Where are we? So the defendant, Justin Johnson, is charged with 3 counts: conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. So I know that you've already gone through a little bit of this law during voir dire, and especially through the jury instructions. But a brief overview of conspiracy to commit first-degree murder is that 1, this defendant entered into an agreement with 1 or more people to commit first-degree murder. 2, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acted for the purpose of promoting or facilitating the first-degree murder. And 4, 1 or more of the parties committed an overt act to help the crime happen. So what did we hear this week? This week we heard testimony from co-defendant Cornelius Smith. He testified for us, and he told us that he met Justin Johnson through Hernandez Gogon, and that he knew Justin was a rapper, and he was also known by the name of Straight Drop. So Smith had known the defendant for a couple of months, and they hung out a couple of times before the murder. He was able to identify defendant in open court, and during his testimony, Smith told us that on November 17th, 2021, he and the defendant knew that Big Jook had a $100,000 hit on Dolph's head. Cornelius said that he and Justin agreed to kill Dolph together, and both of them receiving $40,000 apiece. Not only did he tell us that, he told us that this plan had been in process for weeks, and that Justin knew about it. And there were conversations previously or prior to this murder, and Justin Johnson was an active participant in those agreements. So there we have it, a conspiracy to commit first-degree murder. An agreement was made. Each of the parties had the intent to commit the first-degree murder. Each person acted for the purposes of promoting and facilitating. And, ladies and gentlemen, the overt act is the killing. Next, first-degree murder. In essence, a first-degree murder is a premeditated killing of another. What's required for first-degree murder is 1, that the defendant unlawfully killed the victim. The only way to lawfully kill someone is if you are in protection of yourself or others. Second, you have to prove that this defendant acted intentionally. Intentionally means that there was no mistake, there was no accident. Third, you have to prove that the killing was premeditated. And as we saw, or as we learned in voir dire last week, premeditation does not mean that you had to have this plan for months, weeks, or days in advance. It could just mean that you simply stepped out of your car, you held up your hand, you pointed a gun, and you shot and killed somebody. As long as you had a moment to think about what you were doing, that's premeditation. Next, so we heard from a couple of people this week. First, we heard from the victim's sister, Erica Thornton. She testified that the victim was a living person. He had a family, he had children. She's known him her entire life. She attended and planned his funeral service. And coupled with that, defense counsel and the prosecution agreed to a stipulation, which just means that they agreed to establish that this victim was a living person who was now deceased. Later on, we heard from Dr. Scantleberry She was the medical examiner and performed the autopsy. She found that there was a total of 22 gunshot entry wounds, including gunshots to the back torso, front torso, head, neck, upper extremities, and vital organs. She also testified that on the property that was collected from the victim, there was no weapon. And we also heard from Raul Hawkins. He testified that he was head of Dolph Security for years. He was able to identify Dolph's car in the beginning of the Makitas video, and he was also able to explain the difference between CMG and PRE, their history of conflict, rivalry, diss tracks, and even prior acts of violence that were towards Dolph. So with all of this testimony, we've established that there was a killing and that the victim was Adolph Thornton Jr. But was that killing unlawful? Was that killing premeditated? And was that killing intentional? Back to Cornelius Smith. In addition to testifying about the agreement that he and the defendant entered into, he also testified about the killing. He said that on the day of the murder, the defendant picked him up from his father's house. They both knew that the victim was doing a turkey drive with several of his PRE artists. They also knew that Big Jook had a hit out on all of the PRE artists. So it was their job that week to find them. And on November 17th, 2021, Cornelius Smith and Justin Johnson were on their way to a turkey drive in Westwood. As they were about to turn the corner, they saw a familiar car cross the intersection, which happened to be Dolph's car. Cornelius tells us that they followed the car, made a loop onto a back street, and then entered the Makitas parking lot. And this happened, I want to say, about 30 seconds after Dolph and his brother arrived at Makitas. Cornelius Smith was able to point out himself in that video and the defendant in that video. And he said that both of them were the shooting suspects in that video. The second suspect that got out of the car was wearing a black hoodie, gray pants, black shoes with white soles, and a Bass Pro hat. The same clothing that defendant Justin Johnson was seen in as he was exiting his apartments at the Crosstown Concourse. After the shooting, Cornelius Smith testified that they got into the white Mercedes that they committed the act in. They went to Bradley Street. The defendant parked the white Mercedes on the yard, and they both got into a white Ford Expedition. They both got into that Expedition, and on the way, a couple of calls were made, right? Cornelius tells us that a FaceTime call was made to Big Jook. In that FaceTime call between Big Jook and our defendant spelled out the word Dolph. And as they were on their way to the Gospel Gardens apartment, the defendant also contacted a few other people who we'll find out later on. So once the defendant and Cornelius Johnson arrived at Gospel Gardens, they received wound care. They change their clothes, and then they go their separate ways. After they go their separate ways, Cornelius Smith tells us that he went to retrieve his phone, and he went to go wipe down the car, the white Mercedes that was parked at Bradley. So with Cornelius Smith's testimony, we have established that the killing was unlawful. There was no evidence to show that this defendant was in fear, was protecting himself, or was protecting someone else. We also established that it was intentional. It's not an accident. You didn't mistakenly follow someone's car into Makita's parking lot and then shoot them. We also established that it was premeditated. They knew about this hit beforehand, and they committed this hit. So if that wasn't enough for you, we heard from some other people. We heard from Kirsten Gardner. He testified that he was present during the time that the defendant was able to get possession of the white Mercedes that the act was committed in. Kirsten Gardner was at the Valero gas station in the early hours of November 17th, 2021. Next, well actually, let me go back to Kirsten Gardner. After he testified that, he told us that he didn't know anything about what was happening the next day, or a few hours after the cars were switched. Similarly, Jamarcus Johnson didn't know anything either. He just knew that he needed a ride. And his brother, Justin Johnson, could provide that for him. So he got his car, the rental car, and he took his cell phone, he fielded his calls, posted on his social media, and checked his emails. After Jamarcus Johnson, we heard from Sergeant Dabney. He was able to tell us about the 4 different bullet casings that were present at the murder scene. .40 caliber, attributable to a handgun. .762, attributable to an assault rifle that Cornelius Smith had. .223, attributable to a semi-automatic that Marcus Thornton probably would have had. And a 9mm casings found inside the store, which could be attributable to the handgun that Marcus Thornton had inside the store. That first one, though, the .40 caliber attributable to a handgun, was in the hand of the suspect with the Bass Pro hat. So, Sergeant Dabney also recovered the surveillance footage from Nikita's and Gospel Gardens, showing this suspect in the same clothing that the defendant was in as he was leaving his apartment at 10:49 a.m. that morning. The timestamps on Gospel Garden and Nikita's coincide with the times defendant's phone accessed those towers. We heard from Special Agent Garner, who summarized that the defendant's phone accessed a tower that provided coverage to the Valero gas station at 3:17 a.m. Around the same time that Kirsten Gardner said that he saw the defendant take possession of that white Mercedes at the Valero gas station. The defendant's phone also accessed towers that provided coverage for the area of 2370 Airways Boulevard, which is our murder scene. And it accessed those towers during the times of the murder, 12:22 p.m. to 12:23 p.m. on November 17th. Officer Garner also explained that the defendant's phone accessed a tower in the area of the 2-lane road and Shelby Drive from 1 p.m. to 1:59 p.m., which is the direct correlation to the surveillance footage of Gospel Gardens and the footage that Officer or Sergeant Dabney identified the defendant being present for. So next, if all of that wasn't enough, we heard testimony from Sergeant Browning. Sergeant Browning said that this defendant's device placed an outgoing call to Anthony Mims at 12:25:40 p.m. on November 17, 2021. Not only did he place an outgoing call to Big Jook, he also received a text from Kiana Hooper, who is his cousin. She texted him an address of 4752 Haven Court. After he received that address, he then sent that address to an associate named Jermaine Sears. Jermaine Sears, or defendant's device, sends the outgoing text to Jermaine Sears that he needs him. And you'll see in the surveillance footage of Haven Court on that day, at that time, a car that is associated with Jermaine Sears arrived shortly after the defendant arrives in a white Ford Expedition. So the next thing, convicted felon in possession of a firearm. The 3 things that we have to prove beyond a reasonable doubt is that 1, this defendant was a convicted felon or convicted of a specified felony. And 2, after being convicted of a felony, this defendant possessed a firearm. And 3, this defendant acted intentionally, knowingly, or recklessly. So the facts that we have for this charge. Well, 1, there was a stipulation or an agreement. the parties have stipulated that defendant Justin Johnson was convicted of the felony on May 2nd, 2017 in Criminal Court 8 in Shelby County, Tennessee. Next, we heard testimony from Cornelia Smith, who verified that the person in that Bass Pro hat was Justin Johnson, and that person held a gun. So based on all of that, we can see that we have met our burden of proof for convicted felon in possession of a firearm. Next, let's just talk about reasonable doubt for one last second. Reasonable doubt, it is not 100% certainty. It is not beyond a shadow of a doubt. It is not beyond all doubt. What's required is moral certainty. Certainty that allows you to sleep well at night. Will you be able to rest easy knowing the decision that you've made? My instinct says yes. And once you've had time to deliberate, I think yours will too. So that brings us to the end. The state has met its burden of proof beyond a reasonable doubt. You have all the evidence, all of the testimony, all of the stipulations, all the videos, all the photographs, and now it's time for you to consider that evidence and apply your common sense. And after you do that, I think, well actually I expect, that you will find this defendant guilty on all charges. Thank you.
Thank you, Ms. Williams. Sept.
Thank you, Judge. It's good to see y'all again. This is the last time you're going to have to hear from me. And as I see all of your faces, I know that's something you're looking forward to. And that's okay. I know that you all want to get back to your lives. And I can tell you on behalf of Mr. Johnson that your attention during this trial is greatly appreciated. What you've had to set aside in order to provide this service, I have no doubt that the court and Mr. Hagerman, Ms. Iris, all of us agree you're indebted to you for that. Because like I said in opening, this is important. And you're about to have to roll up your sleeves and go to work. And it's going to be a difficult job. This young man's fate is in your hands. The concept of justice, right? We talked about that in Fort Dyer. We talked about that again in opening, right? And it's in your hands. Meting out justice. And it's difficult because what you've heard is the tragedy of someone losing their life, of their family members not having that person in their life. And that is terrible, and the court will tell you, as terrible as that is, you can't consider that when you're determining guilt or innocence in this case. But it's heavy. And on the other hand, you have Mr. Johnson. This young man that you heard in the evidence is a young man, aspiring rapper. Wanted to make it as a rap artist. When you're going back through these exhibits, you're going to see a picture of him in front of the house on Bradley. You know, engaged in a music video, right, for his rap. Hat kicked to the side, kind of grin on his face. Because that's what he wanted to do. And his fate is directly in your hands. And like we talked about, it's never justice to wrongfully convict someone. And so that determination that you're going to make beyond a reasonable doubt, is the heaviest one, maybe one of the heaviest decisions you'll ever make. And you've had an opportunity to sit through the trial and hear the evidence, observe the witnesses, and you've been told, keep an open mind. And I hope you have, and I'm sure you have. And not to talk about the case. You know, the thing that you've been listening to for days, with people all around you that have going through the same thing, and then you have to be around them even when you're not here, and you can't talk about the elephant in the room. But today that changes. And not only are you allowed to talk about it, the judge has instructed you that you have to talk about it. And to engage in deliberations meaningfully. To listen to one another, to review the evidence that you've heard, to talk about it, and render a decision. But to the degree you're working together, what you never have to do is abandon your conscience. Now, I don't mean conscience like Cornelius Smith in that conscience, right? Because I don't think he really meant that when you heard from him. He said, oh, the reason I decided to tell the truth is I got a conscience. And we all know that's not the type of thing you're dealing with. You take that more seriously. You mean it. He didn't. You've heard a lot of concepts, you know, the terms of art and the law, the burden of proof, presumption of innocence. And when we started this, I told you, Mr. Johnson sits before you innocent. And I'm again telling you today, after the state has closed its proof, he remains that way. He didn't kill Adolph Thornton Jr. He didn't conspire to kill Adolph Thornton Jr. And he wasn't the man holding the pistol in the Makita video. And it's going to be up to you to decide that. To watch those videos. Watch them closely. They want to talk about those videos, and I'm encouraging you to study them. Give them a close look. The state doesn't want to acknowledge what I told you in opening, and that is similar, it doesn't mean the same. Plenty of people have gray sweatpants, black shoes with white soles, black hoodies. And as we learned through the proof, in Memphis especially, and elsewhere, Bass Pro ads. You can look at it, if we had a window, you could look at it and you could see the Bass Pro, which is the pyramid here. You also heard testimony about it being a fad at that point in time. Famous rappers wearing it. Other famous artists. I think I mentioned Gwen Stefani wearing Bass Pro. One rapper has a signature Bass Pro hat. You heard from one of the detectives that they even interviewed someone who gave them a potential suspect that wasn't Mr. Johnson and said that person always wore a Bass Pro hat. And you have to consider that. And then you have Sergeant Dabney, who, for the first time, and I think he acknowledged this, sitting on the stand says, I think those underwear are the same. They're both blue. You look at the underwear from Tulane Apartments, you look back at the Makita video, those are the same underwear. Look at it. Look at the steel shots. And for yourself, determine, can you tell if those are the same? And as jurors, you get to make that call. You get to look at it for yourself and compare those. we've heard a lot about it's not 1981 anymore. And I agree, right? You know, we've got cameras, but like I told you in opening, what also has advanced tremendously since 1981 is the world of forensics, right? Fingerprints, DNA, touch DNA. And you have to ask yourself, why is Justin Johnson's DNA nowhere in that car? There's DNA in that car. You heard a lot about they wiped it. Cornelia Smith said he wiped it. And we'll get to whether you believe that or not in a minute, okay? But he says he wiped it. But he didn't. There's fingerprints on it. Kristen Garner's, Trayon Ingram's, and Cornelia Smith. There was DNA found. One of it coming back to Trayon Ingram, right? Not Justin Johnson. Now, there's a lot of talk about gloves, right? They made a big point to say, you see gloves in the video. Now, they want you to believe that Mr. Johnson's running around in this Mercedes, and the reason that his prints aren't on it are because he's wearing gloves. And mind you, Cornelia Smith, when he said he wiped the car, never said he wiped the driver's side of the car. Okay? If you believe that. And they want you to believe Mr. Johnson's driving around this white Mercedes, including with his daughter. Look at those videos. You think, he's not wearing gloves. And he's got a little girl in tow that would presumably be in that car with him. No DNA recovered. None. Now, during proof, it was interesting because they would show the Mercedes go into crosstown and the Mercedes leave crosstown, and they would show a video of Mr. Johnson getting out and walking in the building or walking out of the building. There is no video that shows Mr. Johnson in that Mercedes. And you heard they had a reel, right? The video was a reel when they're doing crosstown, and when I asked it, I think it was Detective or Sergeant Dabney, about there was surely other cars going in and out at this very time. And he said, yeah. But you have to ask yourself, was Justin Johnson ever in that Mercedes? So let's go to Kristen Garner. Kristen Garner gets up here and tries to tell you that. He tries to say he didn't know the car was stolen, that Trayon was driving around in the car. And at first, he acts like, even under questioning from Mr. Hagerman, that he wasn't even present when the car was exchanged, because he tries to say, well, Trayon told me. And if you recall, Mr. Hagerman had to kind of go back at him, and I think he said something like, I can't tell you that, and then he eventually started answering some questions. You also remember that this is the same guy that went into law enforcement and said, I've never been in that car. I don't know a guy named Justin Johnson other than on Instagram. He's a rapper. And then suddenly, he starts evolving through the story. Still lying, mind you, to law enforcement. He even looks at a video of himself, right, pumping gas, and goes, that's not me in the video. And he's like, okay, it's me. But they're trying to tell you Justin Johnson's at the Valero gas station, right, when he's pumping gas. Where is he? Now, they want you to believe that this shadowy figure up in the right, top corner was Justin Johnson. and that he was the other passenger in the Infinity, but you can't really make out who he is. You have to rely on Kristen Garner. That's what you have to rely upon. And we talked a little bit about, proof beyond a reasonable doubt. And I said one of the ways that you could use to kind of understand it is proof so convincing that you would not hesitate to rely upon it in making the most important decisions of your life. And it's really simple, right? You look there and you go, would I trust Kristen Gardner with anything? If he told me something, would I believe it? The answer is no. Because the more he talked, right, the more you realize he and Trayon are in the Mercedes. They're driving around with a Draco rifle, assault rifle. The same one described as being held by Cornelius Smith in the shooting of Adolph Thornton Jr. Their prints are in the car. He says they have, what he said, a ton of guns in that car. And then he starts talking about how he's related to Dolph, and they were trying to dump the car before, right? And he's reaching out to Dolph's people to try to get rid of a car, which is the reason why after this happened, immediately, day after, he's calling Trayon going, my name's in this. My name's in this. Why would his name be? And B, why couldn't he just say, I don't have anything to do with this? And at Valero, you do see Trayon and Kristen. They're there front and center. Now, there's been a lot of talk about the phone and location. And in the state's argument just now, you heard her saying what the expert said, a phone using, a tower that could be and he said could be. He said was in the service area of the Valero gas station, or then he said, I didn't do any drive tests, so I can't say what the coverage area would have been, right? And when you're looking at his slides, you've got that really thick PowerPoint exhibit, you'll be able to look at it. And you notice, right, that you're going to notice that the pictures are all really small. They're really zoomed in on the map. And he's talking about, like, this, do you think this is thorough? This is thorough. I mean, he's going through all these calls. Look at what he's doing. I mean, but then you have to ask yourself, well, what happens if you expand the map? And then you realize, and this is the exhibit I entered, you realize he's not even counting all the data and calls, because when you show what he left out at 12:23, right, at the time immediately after Adolph Thornton Jr. was shot, there are several towers that Mr. Johnson's phone gets off of that are, one's 3 miles away in one direction, the other one is 3.2 miles away down by the Memphis airport. And then he has to go, I left those out. Not a really good explanation for why, right? Important. When there are a group of fine people that are looking to find the truth and have to make this decision and need to evaluate the accuracy of what he's telling you. And then you realize that when you talk about coverage areas and where things are in relation to these phones, somebody could be anywhere in a 3-mile radius, either any direction. And then you have to go, what is it? What does it show us? How did that help? How does that make you any more certain of someone's presumed location at a given point in time? Because he said it's not an exact science, and I'm not here to tell you that I can pinpoint where he is. And I didn't do drive testing, and I don't know. The next available tower is what a cell phone normally would look for, but also I can't even tell you if the towers were down at the time. That could make a difference. That could put you further out. I couldn't tell you if they were down for maintenance, if they were overburdened, and he said, look, if the tower's real busy, it'll direct you to the next tower. But what it doesn't establish is that Justin Johnson was involved in the conspiracy to kill Adolph Thornton. It doesn't establish that he killed Adolph Thornton or possessed a firearm. Now, a little bit about conspiracy and some more of the facts as you heard them from some of the other witnesses. Now, I have to take a little bit of an issue with the state on something that was said during their initial argument. And that is this. There was no evidence at all that Justin Johnson was present for any meetings discussing this hit. What Cornelius Smith said was he met with Hernandez Govan and Juk, and Justin Johnson was not there. And then he said he met with Hernandez Govan and others on another occasion to discuss it, and Justin Johnson was not there. So to suggest that he was present and agreed, where's the agreement? He wasn't there. Now, you get to Mr. Smith. The court has already instructed you about accomplice testimony and is already warning you that when you're considering that, you have to use caution. Now, you also have to apply the credibility factors that are in the jury instructions, but they're not an exhaustive list, right? Like we talked about in voir dire. Some of you, most of you, probably all of you have had to talk to somebody before and go, are they telling me the truth or not? And that's exactly what's here. But accomplice testimony is flagged because that person may have an interest in the outcome of this case. And you go, what is that interest? Well, Cornelius Smith, number one, told, he had to admit, he didn't want to admit it, but he's meeting with the state. He's hoping to get a benefit on his own sentence. He's supposed to be telling the truth. But he's writing his sisters at the exact same time that he's meeting with the government, or the state rather, and telling them, I didn't do this, I'm just lying to get the deal. I'm just lying to get the deal. Now, is that his conscience, like he wanted to say? No. That's him telling his family. Why would he lie to his sisters? If he had a conscience, right? If he had done this out of the sense of, I did this awful thing, I feel awful, I've got to accept responsibility and tell the truth. No. But you remember, And it was kind of an interesting moment when he was testifying, because at one point he says, "Oh, that's not lying. I was gaming. Gaming's not lying." And the unfortunate part of all this is he's gaming everybody, including trying to game y'all. That's the problem. And he thinks he's going to walk. I mean, and the only person in this case who got paid for this. Remember, there is no proof whatsoever that Justin Johnson got a penny. Cornelius Smith got 50 grand for a lawyer for killing Adolph Thornton and didn't have to give it back. He didn't have to give it back. His lawyer was in the courtroom. And I asked him, I said, you remember, I said, how could you? You didn't give it back, you grew a conscience. What's going on with you? And he went, well, I did it. Service is rendered, right? And the lawyer, he's talking about with his sisters, he's saying, oh, well, my lawyer's telling me to cooperate. I'm walking. I'm not doing it unless I can walk. Now, he was asked by Mr. Hagerman, have I ever told you you're not going to have to go to prison? And he said, no, you haven't. But you have to keep in mind two things, right? At the time he was giving all this information that made him valuable to come in here and talk, he thought he was getting out. That's when those letters are going out. Those letters are going out, and he thinks he's getting out because he's got the lawyer, they got the cooperator from Ali Bobo to walk. And that's the type of thing you have to remember when you're assessing whether you can rely upon Cornelius Smith and anything that he said. The guy that sat in that chair, and he was asked by Mr. Hagerman, when you killed Adolph Thornton, what did you feel? And like it was nothing, said, I didn't feel anything. Let's try to get paid. And that's the guy that they want to put in front of you and say, believe it. You know, he went and talked about exchanging money, right? Getting $800, right? At one point said, do you find people that he got that Mr. Johnson somehow came back into town and he talked on the phone with him and brought $500, and then some other time some other guy in a Chrysler 300 showed up and provided money to his girlfriend. Well, two things. One, that's not what Mr. Smith originally said to law enforcement. He said that Chrysler 300 came twice, and then Mr. Justin Johnson wasn't anywhere in sight. Well, and what do you know about the Chrysler 300? Jamarcus Johnson, right? Did Jamarcus Johnson say when he was here in front of you, did you ever hear the state ask him, did you deliver the money? Is part of you being involved in helping Mr. Johnson? Did you deliver money for him? I mean, he asked about the email, or the text rather, about Cornelius emailing Justin's phone and saying, essentially, I need money for the birthday party. That's because Cornelius Smith is lying from start to finish. And then for the first time ever, here in court, He says he wiped the card out. Who's in contact? Who's in contact with Govan? According to Mr. Smith. Mr. Smith. Who's not in contact with Govan? Mr. Johnson. Did you hear anything about that? Now, when you go back in the jury room, you're going to be reviewing, obviously, these videos. And one of the things that you have to kind of ask yourself is timing. When you see Mr. Johnson in the elevator with his little girl leaving Crosstown that morning, and of course, you know there's going to be one exhibit that's the reel where the state had on it 11:51 in the morning. And then, of course, Mr. Hagerman came in, acknowledged the mistake to say that wasn't the right time, and put an officer on the stand, the lieutenant, to talk about getting access to the time, how he got the timestamp. But what that shows you is this. They don't know what time it was that day on that video. They don't know. I mean, mistakes get made. I'm not here to suggest that they don't. But you have to ask yourself, okay, the mistake got made, and then there's a timestamp. Okay, we want to put the timestamp one in. That seems like the logical choice. But then you have to listen to the lieutenant, right? And go, Lieutenant, what did you do to check and confirm that these were accurate times? Well, I looked at the live feed when I was in there. I had to have a technician, it's a computer, I don't understand it, but when I was there, I looked up at the screen and it appeared to be the right date and time. But not one person, you didn't hear from anybody that could say, that was confirmed, that's accurate, nothing happened with the system beforehand. And you even heard him say, it is not uncommon at all to pull surveillance cameras that have inaccurate date and times. Because you have to ask yourself about timing. You have to ask yourself about timing of leaving Crosstown, Mr. Johnson presumably going all the way to Whitehaven, if he's in that Mercedes and dropping his daughter off, right? And he said 20 minutes, something like that. Then he's supposedly driving all the way back to Wild Rose, 20 minutes, thereabouts, to pick up Cornelia Smith. They got to leave, then turn around and go to Bradley and go back to the white truck, right? And then get out and be in front of the Makita Cookie at 12:21. Now, that part of common sense and your everyday experiences, what does that tell you about going one place to the other? Right? Takes longer, right? If you're stopping places, if you got to park, if you're presumably dropping a child off, there's going to be some kind of a exchange of a child, maybe a discussion with a person, and you build all that in. That's a lot of time. And I would submit to you that one of the reasons that became an issue is about correcting that time is when the state realized that I was asking questions of that witness and asking him how long it would take to get from point A to point B to here to here to here. Because when you do the math and it's 11:51, it doesn't work. It doesn't work. You know, and all this about Bradley, even the exchange of the Mercedes for the Infiniti, the dropping of the Mercedes at Bradley and picking up the SUV, whether somebody cleaned the Mercedes or didn't, who moved their Mercedes to the backyard, all of that, according to Cornelia Smith, should have been captured on Hernandez-Govan's home security system. Right? He said Govan had a security system directly facing Bradley because that's why when he decided that he was going to go wipe the car down, either the day it happened or the day after, he couldn't quite remember, he texted Govan and said he was coming through there because he didn't want Govan to mistake him for somebody trying to come up on him. I asked Detective or Sergeant Dabney, did y'all canvass? Yes, we canvassed the neighborhood. You know, he didn't do it personally, but he would have presumed they would have talked to everybody, including Hernandez-Govan. Right? We don't necessarily know if they did or didn't, because we didn't get to hear from Mr. Govan. You know, I asked Detective Browning if he was aware of any video from there. No. But if Cornelia Smith, right, is this person that's telling you the truth, because the truth doesn't change, then the fact that there were videos would have been known as early as March of 22, when he was meeting with law enforcement. And you know, I'm not saying law enforcement doesn't want to find out who did this. They would have absolutely went and looked. But we don't know. We don't know. And there's a lot that you should know that you don't. Because there's a material witness that should have been called by the state that wasn't called. Hernandez-Govan. And maybe some of you sat through this and thought, I want to hear what he has to say. And when I told you in the opening statement, I said, it's important, right, for you to weigh out and be able, as part of your duty as jurors, to be able to compare those two testimonies together. I'm sure some of you were thinking, yeah, that would make sense. I know we talked about that in voir dire, about getting two people to talk to kind of differentiate. You know, some of you that may have been a teacher, talking about that as one of the ways that you try to figure out who's telling the truth, who isn't. But you weren't able to do that. You weren't able to do that. You were deprived of that. And to be clear, as you heard about Hernandez-Govan, he was cooperating in this investigation. He met with law enforcement on at least 2 occasions pursuant to a proffer agreement, which meant he was allowed to go in and give information and not have his words used against him later. I don't have the ability to make good on a proffer letter. Only the state does. I don't have the ability to wave a magic wand and give him a reduced sentence if he comes in and testifies for me. So he's to my exclusion. He's to Mr. Johnson's exclusion, and ultimately to your exclusion. And if this is a truth-seeking function, why didn't the state call him? And it is. Your job is to find the truth of the matter. and ultimately to go, did they prove their case or not? But you were deprived of that. And the judge instructed you about a jury instruction. And that's the law. That's part of all the different things she told you. This is as important as any of them. And the law states that it creates an inference that the testimony of that witness, Govan, would have been unfavorable to the state. Now, it's up to you to decide whether or not he was unavailable, a material witness, and whether or not there should be the inference. But you're allowed to make that inference in here. And unfavorable, I would tell you, unfavorable to the state means favorable to Mr. Johnson. And knowing that, can you really render a verdict of guilty and have your mind rest easy? And not walk away and go, I just don't know if I did the right thing. Knowing that there was information out there that could have been presented to you and wasn't, that would have been favorable to Mr. Johnson, that I couldn't give you. Can you be morally certain in that instance? In order to be convinced beyond a reasonable doubt that Mr. Johnson is the one in that Nikita video, you have to consider everything. You have to consider what you heard. And you have to go, what I heard from Kristen Garner and Cornelius Smith, was that so convincing that I wouldn't hesitate to rely upon it in making those most important decisions in your own life? Will my mind rest easy if I convict this young man based on their word in conjunction with that video and the other videos and what you didn't hear? The answer is no. When you examine your conscience back there, after you've taken the time to deliberate, I think you'll find the answer is no. Two things I want you to remember, and I'm wrapping up. The way the burden of proof works. And you've heard this statement, right? They ain't got nothing to prove. You may say that to somebody, like, I ain't got nothing to prove here. Justin Johnson, he doesn't have anything to prove here. They do. And we've all heard the term benefit of the doubt, right? Everybody likes to give somebody the benefit of the doubt. You are legally prohibited from giving the state the benefit of the doubt. You can't carry their water for them. Again, I appreciate it. This is, as I said, the last time I get to speak to you. The state's going to get one more opportunity to talk to you this morning. They get the last word. That's how the system's set up. But it has been my honor to represent Mr. Johnson in this case, and it's been my honor to present this case before you all. And thank you so much.
Thank you, Ms. Dillon. Mary?
We started this with a little Memphis talk. Those cookies are fire. I think that's how we started it. Little more Memphis talk. What y'all even talking about? What y'all even talking about? A missing witness? Hernandez Govan? A missing witness? Hernandez Govan? Absent material witness. And the defense wants to say that is Hernandez Govan? What do we know about Hernandez Govan? He's a defendant in the case. He is charged with murder and conspiracy to murder. Whether it's from television or whether it's in black and white at the bottom of that same instruction, a defendant has the right not to testify and incriminate himself. He is a defendant. He is not a missing witness. That would be insane. I could willy-nilly just start calling every defendant. And they just have to come in here, testify. That's crazy. It doesn't even work like that on television. It doesn't even work like that in black and white in front of you. That would be insanity, and that wouldn't be a legal system where you had a Fifth Amendment right. That would be an inquisition, is actually what they used to call it, where you didn't have that right not to come in the courtroom. So the idea that the defense would call a defendant who's charged with this crime an absent witness shows you how desperate it is. And then we'll talk about things in isolation. Look at Kirsten Gardner. I'm sure he knew that car was stolen. I'm sure he did too. Well, then how can you believe him? Or look at Cornelius Smith. I'm sure it's not his conscience that made him talk. I'm sure it's not either. He talked because he's caught. So don't believe him. Somebody made a mistake on one slide about the time, so it was corrected. So we can't believe the video. You know, there's a word that actually exists because it's a thing. It's corroboration. It's corroboration is what they call it. Like, can you look at something somebody's saying and compare it to something else and then determine whether or not that person's telling the truth about it? Because that's how we should judge stuff. Did Kirsten Gardner know the car was stolen? I bet he did. Does he think Treon Ingram actually paid for it because of something? No, we didn't pay for the car. They're riding around with guns in a stolen car, and they're trading it with their buddy, Mr. Johnson. But how do we know that? Corroboration. Is there evidence that shows us that? Well, there's the Valero video, which shows something strange. Shows something strange. Shows Kirsten come up in the car and then somebody else get in and drive off. Strange. Another little piece of corroboration, where's Justin Johnson's phone at the time? Well, in the area of the Valero station. Can you say it's in the parking lot? No, you can't. But it's in the Valero, in the vicinity of the Valero station. But my God, is there something else? Yeah. And this is what is ignored throughout the entire talk we just heard. We don't just have towers. We just don't have cell phone towers. We don't just have a Valero video. We just don't have a Haven Court video. We don't just have a crosstown video. We don't just have a defendant who's like, Cornelius Smith, I'm guilty and so is he. That's us two in the parking lot shooting him. We got Justin Johnson's actual phone. We got his actual phone. In this case, it's been over so many times. Things that happen that are actually really dramatic just sort of happen. Because as soon as we saw the video of the Makeda shooting, and as soon as you see the video of Crosstown of him leaving in the exact same outfit, in the white Mercedes, case is over. But we keep going. As soon as you hear from a co-defendant who's like, that's me in the parking lot shooting Dolph, I'm going to prison, and Justin Johnson's the guy next to me doing it, case is over. As soon as you see the Haven Court video, 40 minutes after the shooting, of the two shooters and his cousin, case is over. But then things kept on happening. That if you didn't have all that proof, would have even been more dramatic, or would have been dramatic. When they happened, I would see in your eyes a little thing, a little twinkle. We have his phone. And the night before, we have a text. The night before the homicide, we have a text. From who? Treon Ingram. To who? Justin Johnson. Sending him what? A picture of the white Mercedes. What do we have next? Another text. Justin Johnson. Treon Ingram. Dropping his location. Bradley. Kissed and said. They met on Bradley. Then they drove to Valero. And they switched the cars. That's corroboration. So do you have to be willing to trust Kissinger with the keys to your car? Of course not. You think I'd trust Kissinger with the keys to my car? But do I know he's telling the truth about this? Well, yeah, I do. Because it's on video of Valero. It's documented in his phone with literal pictures and locations. This is plain and clear. Do I have to believe that Cornelius Smith is talking because of pangs of conscience? No. No. He's talking because he got caught. Is he hoping that the truth will help him? Absolutely. He's hoping that the truth will help him. Is he going to prison after this? Absolutely. He's going to prison after this. Is there anything about his testimony, like Kissinger's, that we can corroborate? Well, my goodness. What's the first thing he tells us about that day? Justin Johnson calls me. I think I miss a call, and then I get a second one. And what do we got? Justin Johnson's phone. You can delete your call logs, which he did from that day, but they're still in the phone. And what do you know? 2 calls to Cornelius Smith from him right before he comes and picks him up at Lamar and Steps. That's corroboration. What does Smith tell us? We go to Bradley directly after the shooting, but dump the cars. Dump the cars is important. Because here's another little, real tricky truth test. Justin's driving the white Mercedes. You see it in the video, of course. Cornelius testifies to it. He says, we drive to Bradley. He hands me the keys to the Expedition. I jump out of the car. I get in the Expedition driving while Justin parks the car in the driveway or there on the front. Well, we know the white Expedition is also Justin's car. We've seen it across town for testimony. What did we see at Haven Court? Cornelius says, from there we end up going to Justin's cousin's apartment. It used to be called the Two Lanes, Gospel Gardens, the address on Haven Court. We see the white Expedition arrive. And who's driving? The white Expedition. Justin's car. Who's driving? The dude with the messed up shoulder and the messed up shirt. Cornelius Smith. I mean, how do you make that up? How do you make that up? They pull up at Haven Court with Cornelius Smith driving and Justin in the passenger seat, just like it had to happen, just like Cornelius Smith told you when he testified. We do the shooting. Justin's driving the white Mercedes. He hands me the keys to the Expedition. We get to Bradley. I jump out. I get in the driver's seat of the Expedition. Justin parks the Mercedes, jumps in, Haven Court. And what do you know? That's what we see. And what do you know? If you're lying, that detail is almost impossible to account for. Corroboration. We plainly see in the video, Haven Court. We plainly see them go inside. We plainly see Justin Johnson come out, meet this character in a Dodge Challenger, get some other clothes, get some bags, go in. We plainly see the Chevy Trax come, Angela Arnold, pick up Cornelius. We plainly see Justin get in his car, the Expedition, and the two pull out. His testimony is corroborated over and over and over. And that's so incredibly important as we do trials. That's how we make decisions. Corroboration. That's why we have evidence. That's why we don't just call one witness and say it's over with. We put evidence in front of you. And one of those moments when this trial was just over again for the 5th time was when we were showing the slide from his phone, from Justin's phone. Cornelius says right after the shooting, Justin calls and then FaceTimes with somebody. He says it's Big Joke. The guy that put the money down for this. Number 2 is CMG. The guy that put hits on the other artists too. Cornelius says it's a FaceTime. Spelling out Dolph with your hands. And what do we find in Justin's phone? I mean, delete the stuff all day long. He did. Whole day. November 17th. Deleted all day long, but it's still in there. A call and FaceTime interaction with him. Justin Johnson with Big Joke. With Big Joke. Cornelius tells you. And there you see it in black and white. It's not 1981. No, that's true. Caught on camera and everything else, but you're also walking around your pocket with a phone that you can delete a call log, but it's still there. The times you called Cornelius Smith that morning, still there. The time when you called and then FaceTime with Big Joke right after the murder of Dolph, still there. The videos from Haven Court that show you arriving, still there. The videos of Haven Court that see you changing clothes. Did he have enough time to do it? Well, yeah, he had enough time to do it. He left crossing at 10:51. He had over an hour and a half to go drop off his kid 20 minutes away and drive 10 minutes. Total trip probably take you 30 or 40 minutes. Yeah, you have enough time to do it. We saw him do it. Memphis talked all the times. All the times. Before the murder We see him at Crosstown in the murder outfit. Similar clothing? No. Identical clothing. Patch on the legs, Bass Pro hat, everything. Before the murder, the Mercedes. Similar Mercedes? No. Back end damage, just like we saw in the video. During the murder, again, caught on video, white Mercedes, back end damage, the exact same clothing across town. Looks like him, right-handed like him, gloved up like Cornelia said. Driving away from the murder. Who you calling, who you texting? Big Joe. Caught before, caught during, and then caught after at Haven Court. Video of them arriving and leaving. Caught before, during, and after. That's called being caught all the times. All the times. He is literally caught before, during, and after. Caught all the times. And then what does he do? Then what do we know? Another Memphis phrase. Get on down. Get on down. Across town, the last video. Packing my suitcases to head out of town. Packing my suitcases to head out of town and get on down. Like the police tell us, a manhunt. Not just in Memphis, well beyond Memphis. As Jamarcus tells us, he's going in and out of town. As Jamarcus tells us, he sees pictures on social media, Rolls Royce, stacks of money. Get out of town, get on down. The crime has been committed, Dolph has been killed, and we literally see him at the elevator with his suitcases getting on down. Flight can create an inference of guilt. Well, yeah. This case was over when you saw the videos. This case was over when you heard from the co-defendant. This case was over when you saw him at Crosstown with the suitcases leaving, knowing that the manhunt was coming and he was out of town and leaving. Real guilt. Real guilt. Now it's time for us, though. Now it's time for us to get on down, but we don't get on down by fleeing. We don't get on down by hiding. We don't get on down with pictures of Rolls Royces and stacks of money. We get on down by doing what's right and doing our jobs and looking at the evidence, the witnesses, the corroboration, and applying the law to those things. We get on down by doing justice. We get on down by saying you are called all the times. You are called all the times and you're guilty of all the things. Conspiracy to commit murder? I just heard, okay, let's at least cut him a break on the conspiracy to commit murder because man, he wasn't there for at least like one of these meetings with Big Jook or something. That's what I just heard. Let's cut him a little break on the conspiracy to murder because he's not at this meeting with, Big Jook and Govan and Cornelius. So let's cut him a little break on that. That's what I heard. Let's cut him a little break on that. There's no requirement in the law that every conspirator have to be at every single meeting with each other. There has to be an agreement and an understanding. And there was clearly an understanding. Big Jook is going to pay money to take out PRE artists, and at the top of that chain is Dolph. Now, does he demonstrate any understanding of that? Is there anything he does that shows he's part of this like understanding that this is going to happen? Yeah. He literally shows up with gloves and guns, has a white Mercedes he gets from Treon, has Cornelius driving next to him, and they drive and go do it. So the idea that, okay, he committed the murder, but give him a break and leave, no. He's guilty of the conspiracy just like they're all guilty of the conspiracy. And of course he's guilty of the murder because we watched it on video. Last short thing. Just one lyric. Just one lyric. You too real. Dolph, you too real. He rapped about what he calls come up. What he saw in neighborhoods, what he saw in his family, growing up. Too real. He rapped about people that he had a rivalry with. Too real. Dolph, too real. Included disses of dangerous people like Big Chuck. You're too real. Too real. Too real. Last moments of his life, last seconds of his life. How long was the videotape? 30 seconds? You're too real. Dies on the floor of a neighborhood cookie store in Orange now. It's real. You're too real. Your family misses you. Erica and Mia and the kids. You too real. This is real. This is too real. And when the killer, one of the two, is caught on video, all the times, we even watch him get on down. It's time for us to be real. No, we don't need Memphis talk for that. It's called just do what's right. It's as simple as that. Just do what's right. Cornelius Smith and Justin Johnson killed Adolph Thornton Jr. November 17th. We watched it happen. Cornelius Smith, Justin Johnson, Hernandez Govan, Big Jook, they all conspired to have it done, and it was done. November 17th, 2021. And as he did it, he was already a convicted felon. He should be found guilty of all counts. You do what's right. That's how we do. Guilty conspiracy to commit murder, murder in the first degree, and convicted felon in possession of a handgun.
ladies and gentlemen, I got a few more pages of the charge to read to you. I'm gonna pick up on page 29. Verdicts. Count 1. The charged offense in the first count of the indictment is conspiracy to commit first-degree murder. The lesser included offenses in order of consideration from greatest to least are facilitation to wit, conspiracy to commit first-degree murder. When you retire to consider your verdict in the first count of the indictment, you will first inquire whether the defendant is guilty of conspiracy to commit first-degree murder as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of facilitation to wit, conspiracy to commit first-degree murder as charged and included in count 1. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of facilitation to wit, conspiracy to commit first-degree murder as charged and included in count 1 of the indictment. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the first count of the indictment under the law defined and explained to you, it is your duty to acquit him. The verdict will be: we, the jury, find the defendant not guilty as to count 1. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. Count 2. The charged offense in the second count of the indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. You will next inquire whether the defendant is guilty of first-degree murder as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, second-degree murder, as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of second-degree murder as charged and included in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, facilitation to wit, first-degree murder, as charged and included in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of facilitation to wit, first-degree murder, as charged in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least, as set forth on the previous page. If you find the defendant guilty of a lesser included offense, your verdict will be: we, the jury, find the defendant guilty of, as included in count 2 of the indictment. Insert a lesser offense in the blank. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the second count of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be: we, the jury, find the defendant not guilty as to count 2. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. Count 3. The charged offense in the third count of the indictment is convicted felon in possession of a firearm. There are no lesser included offenses. You will next inquire whether the defendant is guilty of convicted felon in possession of a firearm as charged in the third count of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be, we the jury find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the third count of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdicts will be, we the jury find the defendant not guilty as to count 3. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict on a particular count, the foreperson will write your verdict as to each count on the outside of the jacket and sign his or her name to the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and return to the court with verdicts that truth dictate and justice demand. All right, as I told you before, this is the official copy. Please refer to it. There's just been a couple of minor changes made, but nothing substantial, nothing substantive. Let's put it that way. A few typos I ran into, but other than that, please use yours, make notes on yours, refer to yours. But this is the official copy if there's any discrepancy. The jacket, please. You will have all of the exhibits to go back with you. Please look them over. If at some point you want to watch videos, please let us know. Do you have did you make the list? Okay, is it?
It's been numbered as an exhibit, Your Honor.
Okay, so it's with the exhibits. Do you have a clean laptop so they can you get us a clean laptop so they can watch videos as they want to watch
They'll get it,
videos?
Your Honor.
Thank you. So you will be provided a laptop that's clean, so you can watch videos how you want to watch videos. And there will be a list accompanying the video to show you, to tell you, describe to you which video is which. Does that make sense? Okay. So, is everybody in good shape to deliberate? You getting ready to choose alternates? Everybody good to deliberate? I'm going to call three numbers. Once all three are called, The deputy will escort you back to the back to get your belongings. And then if the three of you could come back out here, because I have a few remarks for you. And then the rest of the jurors, the 12 of you that will be seated to deliberate, will go back and begin your deliberations. Okay? Juror number 18. Juror number 13. And juror number 12. You guys can look at these if you'd like. You can review these if you'd
Oh,
like,
yes,
is what I
sir.
said.
Oh, no.
Just always. You can pick one. Just make it a point to show you.
Yes, Your Honor. Thank you.
Lunch should be here in a little while. Let me admonish you now. All 12 of you will deliberate at the same time. There should never be an opportunity where 2 or 3 over here eating and the rest of you are deliberating. If you decide you're gonna eat, everybody eat. If you decide you're gonna take a break, everybody take a break. When it's time to deliberate, everybody deliberate. Just let the deputy know that you're doing something different besides deliberating. Okay? Jurors, you are excused. stands in recess.
Court stands in recess.